this case. Do you have a pretty good grasp on the evidence that was collected and gathered as a result of the investigation?
Yes.
And was there any evidence found at the apartment of forced entry?
No.
Was there any evidence found of that anything had been stolen from the apartment?
No.
In fact, was there a wallet recovered on scene?
Yes.
No further questions at this time, Your Honor.
Mr. Puentes?
Thank you. I've already forgotten what your specific title is, Mr. Rowland. What is it again?
Currently, I'm a deputy.
Deputy. I wanted to call you detective.
I go by pretty much anything.
Good to know. All right, let's really kind of start with, I guess, the interview. There's a fair amount of interrogation techniques, if you will, that exist. Is that correct?
Yes.
But you'll admit you didn't really use any, right? It was really just kind of a conversation between two, or in this case, three guys. Is that fair to say?
I would categorize this as an interview. Yes.
Yeah, I mean, you could have lied to him if you wanted to. Is that fair?
Could have.
But you didn't. Is that correct?
Correct.
There was just, frankly, as we viewed the video, no need for it. Is that correct?
Correct.
This individual, Mr. Behal, gave a full statement, or at least as full as he indicated he was capable of providing you. Is that correct?
Yes.
All right. Now, there were various points during the interview that you were kind to him. Is that fair to say?
I'd like to think so.
And I imagine that's at least part just your natural demeanor. Is that fair?
Yes.
But it's also sometimes just kind of a useful technique, if you will, in that it keeps the individual talking because they're comfortable with you. Is that right?
Sure.
All right. Is that a yes?
Yes.
All right. And there were portions of the video where you'd stepped out, and I believe your testimony during during direct was that you'd stepped out to speak to your partner or the other interviewer to kind of figure out where you'd go next. Is that correct?
That's part of it, yes.
Would you agree that there's also some sort of strategic, value or benefit in leaving the suspect alone?
There can be. Each interview, each suspect, everybody's different. Some people that may be beneficial. In this specific instance, it was to speak with the other individual and to call the units that were on scene, processing the evidence to see if there had been any updates, anything that I should be focusing on.
Okay. Now, I want to speak to you. There was a conversation during direct, and I think the question suggested that the photographs that you took, you were present when they were took of Mr. Behal, that those were a few days later, a few days after March 14th. Is that correct?
Yes.
But to be specific, they were taken on March 21st. Is that correct?
That's correct.
And that is exactly 1 week from March 14th. Is that correct?
I believe that that's the way it works out, yes.
You're sure or you're guessing?
Without looking at a calendar specifically or doing the math in my head, I'm going to take your word that it's a week.
Much appreciated. Now, you testified that when you had first arrived on the scene at 105 Crestview, you were there for approximately a half an hour. Is that correct?
I was inside of the scene, so inside of the building for approximately a half hour. I was on scene for far longer typing the search warrant.
Sure, but again, I guess I should be more specific. Your actual, eyes-on or inspection of the apartment, the interior of the apartment, was approximately 30 minutes.
Yes.
Okay. And by the time you had spoken to Mr. Behal, that scene had not been processed yet. Is that correct?
They were actively processing it at the time.
Have you had an opportunity as lead detective to review Mr. or Deputy Grease's reports?
It's been a significant amount of time since then, but yes, I did.
Would you agree or disagree that the date that the photographs were taken and that he himself processed the apartment was actually on March 15th, the day after the interview?
No.
You're not certain or you don't know?
I would not agree that that's what took place.
Bear with me. Permission to approach the witness?
You may.
I'm showing you, it's not been marked, this is simply Alex Grease's report. Can you please briefly review that document? Just tell me if it refreshes your recollection at all.
It does.
This was in fact Mr. Grease's or Alex Grease's report, correct?
Correct.
And he does identify a date that the photographs were taken, correct?
He identifies the date that the photographs processing the evidence after their collection was taken, but not the processing of the scene in Parkview.
Okay, again, what was the date on the report?
The date on the report you just handed me was March 15th, the next day.
Thank you. Do you know when the DNA was sent to the DCI laboratory?
Not off the top of my head, no.
Okay. Does the 19th sound right? March 19th?
It may be,
Okay. And that would be 5 days after the interview, correct?
yes, that would be.
Now, you've already testified to this, but you were lead detective on the scene that night, correct?
Correct.
And with respect to your CV and I think your testimony, you've already indicated that you started law enforcement with Scott County specifically in May of 2021, is that right? I'm
No.
sorry, July 2019, is that correct?
Correct.
All right. And your first, we'll call it a rotation as deputy sheriff, terminated on May 2021 when you then transitioned into detective, is that right?
Correct.
And then you were detective until you transitioned back, I understand, to deputy. Approximately when was that?
That was January of this year.
Okay. And those are generally approximately 5-year rotations. Yours was just shy of that, is that correct?
Correct.
All right. And that's at least part of sort of why there's a transition, is that there's a natural kind of, I guess, transitioning in and out of some of these positions. Is that fair to say? It's kind of weird, it was weirdly worded, but I think you understand what I'm saying, is that right?
Yes.
All right. Now, I do want to just briefly go through your CV, because I think there's some relevance to it. You did draft this document, right?
Correct.
It's not drafted for you, correct?
Correct.
So the materials that are contained within it, you placed there, not someone else, correct?
Correct.
All right. May I approach just for use of the Elmo, Your Honor?
You may.
It's already been introduced and admitted. This is Exhibit 37. There was some conversation about it already. I just want to clarify some things that, again, I think might have been covered during your direct, but just want to circle back. Thank you. And it reads like it's chronological from approximately the time you started as detective with Scott County Sheriff's Office. Is that correct?
Yes.
Minus, of course, the Law Enforcement Academy, Military Police Academy, that were all listed at the top. Is that correct?
Correct.
Following, after that, there was interview and interrogation techniques, which consist of 24, is that academic hours?
I believe so. It's a 3-day course.
Okay. And then we're talking about White Collar Crime Center, is that correct?
Correct.
And you illustrate, it looks like that's mostly digital forensics type coursework, is that correct?
That's correct.
On the second page here, I have no idea how to pronounce that, what that says, if that's an acronym. What is that PATC Tech?
So it's PATC Tech. It's a digital forensics practitioner training firm.
Okay. Below that is Celebrite Technologies, is that correct?
That's correct.
And you've already testified about that, I believe, during direct, but can you just, again, reiterate what is Celebrite in generic terms?
Celebrite is a digital forensics vendor where, as I said previously, they provide software and hardware for extracting primarily mobile devices, but they also have offerings for computers.
Okay. Followed by National Computer Forensic Institute, is that right?
That's correct.
Followed by, why don't you tell me what that technologies is? Again,
Sure.
I don't know how to pronounce that.
That's Griffi Technologies. Since this was drafted, they've been procured by Magnet Forensics. Griffi Technologies is specifically a media processing tool where you can pull photos, videos, audio into Griffi and just be able to more efficiently and quickly process that information.
Okay. And then there's the Dallas Annual Crimes Against Children Conference in 2022, followed by really kind of more of the same, crimes against children. Am I reading that correctly?
Correct.
And it looks like, again, more or less, the bullet points illustrate that it's kind of digital forensics in nature, maybe child pornography, those style of cases. Is that fair?
That's correct.
Okay. And then page 3, is that, I'm assuming, a similar conference to the one had a year earlier in 2022, the Dallas Crimes Against Children Conference? Is that?
Yes, sir.
Okay. Then National Computer Forensic Institute, is that correct?
Correct.
Followed by the National Computer Forensic Institute, looks like just the following year.
Correct.
And then, I don't know if you attended that twice or it was maybe a more strenuous program that you attended, but similarly titled that followed, is that correct?
Yes, so the earlier one in 2024 is for the vehicle forensics course. That's detailing specifically vehicle forensics, infotainment centers. And then the following one is the mobile device examiner, which primarily focuses on cell phones, tablets.
Okay. So is it just kind of I guess a fair summary to say that your significant specialty, if you will, is in computer forensics?
Correct.
And that's the space, at least, in which you've been the most trained, as evidenced by your CV. Is that correct?
Correct.
Okay. Now, I think there were just a few things that I want to chat with you about that we haven't discussed already. There was a question about the lap belt, and it had some blood, but it didn't seem like a lot on it. Do you sort of remember that question?
Yes.
But you don't contest that Mr. Behal had been bleeding that evening, correct?
No.
I assume you had evidence or later gleaned evidence that when he was found, he had blood on his shirt, his shorts, and on his foot. Is that correct?
Yes.
All right. And it was also later determined while at the hospital, I don't recall which officer it was, but his body camera revealed that the blankets that were laying on Mr. Behal were saturated with blood. Is that correct?
Correct.
And at least the blankets that were underneath him, which you personally collected and photographed, it didn't have a tremendous amount of blood, I think, to be fair, but it did have blood present, correct?
Correct.
And you certainly, if not at the time you interviewed him, you later discerned that he had an injury to his left side. I think you described it as a laceration. Is that fair?
Yes.
All right. So again, we're not contesting that. But you would also agree a lap belt is not exactly a absorbent material.
Correct.
Okay. Now, when you started the interview, you testified that you tried to ascertain sort of his sobriety, I guess, for lack of better words. I don't want to say his level of comprehension, because that's not something you can deduce, but certainly his sobriety is something you might be trained to ascertain. Is that correct?
Yes.
Okay. And you were using some tools or some tips, some tricks maybe, to try to decipher those things. Is that correct?
I'm not sure that I would categorize them as that, but if that's how you choose to do it, then yes.
That's fine. I won't get caught up on the terminology with you. What I will ask you, though, is you were trying to figure out if he was sober, correct?
Correct.
All right. And in order to do so, you asked them for some sort of demographic or biographical information. Is that right?
That's part of it, yes.
And he'd answered all those questions to your understanding accurately.
Yes.
Okay. And what time, by the way, did this interview start?
It was around 9 a.m., I believe.
Okay. And this is after he'd already been treated and released from the hospital, is that correct?
Correct.
Do you know whether or not they gave him IV fluids at the hospital?
Without reviewing the medical records, I don't remember specifically.
You're just not sure?
Correct.
Okay. And from the time of the suspected time of the car accident, which I believe was approximately 1:45, this is 7 hours and 15 minutes later, is that correct?
Correct.
All right. And he, strike that. Now, I just kind of want to go through some things that he'd said. I'm not going to go through everything that he said. It was a lengthy video. But just try to figure out some things. I understand he provided a door code to someone. Can you explain what door code is? I guess what that reference means.
Sure. I believe you're referencing Deputy Turner speaking with him. That would be in the front entrance to the apartment building for 105 Crestview Drive. There's a access controlled common hallway area, and that has a electronic door that has a PIN code that you can use to access.
Okay, and Mr. Behal had given said code, is that correct?
To Deputy Turner, yes.
Okay, and was it determined that that was accurate or inaccurate, the code that he gave?
I believe it was accurate. Deputy Turner responded and said, yeah, we already have that code.
Okay. And we already talked about this, but the biographical information he provided was accurate, is that correct?
Correct.
Okay. He gave I think a year, make, model, maybe color of an automobile that he was operating, is that correct?
Yes.
Was that accurate?
The year was not.
The year was not. How far off was he?
1 year.
He told you where he was living, is that right?
Yes.
And was that accurate or inaccurate?
It was
Accurate?
accurate.
Okay. He told you he had been drinking that night, is that correct?
Yes, sir.
And did you have evidence, at least at that time, that that was accurate?
Yes.
Okay. He told you he was a heavy drinker, is that correct?
Yes.
And was that determined to be accurate or inaccurate?
Through his own statements, I would say that that was accurate.
Okay, did you make any attempts to vet that out?
I know that there was previous interactions.
I'm just asking if you made any determination that it's
Yes.
accurate. Okay. And at least with respect to drinking that night, you found I think it was empty bottle of vodka. I guess I don't know if there was still some fluid within it, but you found a large bottle of vodka, is that correct?
Correct.
All right. Just kind of out of curiosity, you'd asked them about a game called Garbage, correct?
Yes.
And you said that you used it as I believe you said that you used it as a tool to see if kind of he understood the general rules of the game and could explain it to you, because that would help you understand if he was coherent. Is that correct?
That was a basic idea, yes.
Okay. But this was also a game you were unfamiliar with, correct?
Correct.
You didn't know the rules, correct?
At that point, yes.
So had he have just made it up, would you have known?
Much like with the rest of the interview, I take the information during the interview and then use that to corroborate
Sure,
afterwards.
later, but in the moment, was it a useful tool, I guess is what I'm getting at.
I viewed it as, because if he had told me, you know, you throw a deck of cards on the ground and then you just pick up 5 random ones, and the cognitive story that he put together didn't make sense on its face, I would have questioned it more. But the words that he said in the order that he said them made sense.
Okay. Either while at the scene or in photographs, did you determine whether or not he had any kitchen knives in the kitchen?
I didn't specifically search any of the residents. Everything that I witnessed was as it was. I don't believe anybody found any kitchen knives throughout the residence.
Okay. He described, at least at one point, utilizing a knife, is that correct?
Yes,
And you or someone located a knife on scene, correct?
in the vehicle.
Okay. And it was determined that that was the knife, or believed to be the knife that was used, correct?
Correct.
All right. And he said that there was involvement of a bat, is that correct?
Correct.
And that bat was located, I believe, on the couch within the unit, 105 Crestview, is that correct?
Correct.
And he described it as orange in color, is that correct?
Yes,
And was it in fact orange in color?
it was.
I think he described it as being made of aluminum, which I imagine most, if not all, bats are. But it was in fact an aluminum versus a wood or some other type. Is that
It was some sort of lightweight metal, yes.
He attempted to give you a timeline of events that took place earlier in the day with respect to like places he'd gone, attempting to donate plasma, things of that nature. Did you or any officers try to investigate any of those things, whether or not they in fact tried to donate plasma, look for receipts, things of that nature?
Initially, we attempted to do that, but we didn't follow up on that because we didn't view it as adding or subtracting any relevant information to the investigation, so we allocated our resources elsewhere.
So, just out of curiosity, you don't see value in things that he tells you in determining whether they're true or accurate? True or false, I misspoke.
We did.
Just not those things, right?
They did not have specific connection to the argument that may or may not have taken place. So we didn't view them as a worthwhile endeavor when there were other more concrete methods that I could verify the conversation with my set of skills that we'd already spoken about.
Now, with respect to the records, obviously you collected and you testified already records from Facebook for, I believe it was for Taylor Escontrias, Nick Seaman. Did you collect Facebook messages for Mr. Behal?
I did not.
Did you collect phone records of any of these individuals?
I don't believe so.
Is that, again, just something you didn't find to be a useful tool or road to go down?
Correct.
Sure. I just want to, may I approach the exhibits again?
You may.
show you what's been marked as, well, marked and admitted as State's Exhibit 38. This is, I think, if I'm correct, Nick Seaman's Facebook receipts, I think is the word you used, is that correct?
Return.
Return. And I just want to show you this page again because there was already some conversation about it. I think it's chronological from top to bottom, is that correct?
That's correct.
And I think you said that the last four messages that were between Nick Seaman and Taylor McKee, who we know to be Taylor Escontrias, were deleted, is that correct?
If I can demonstrate again.
Yeah, of course.
So it would be everything above this, because this is the first entry for the GIF that is on the next page. That would be the first entry that is present on Taylor's phone.
So the don't reply text, that was deleted.
Correct?
The if I get text was deleted.
Correct.
The I need to get it checked text was deleted.
Correct.
And the liver is probably text was deleted.
Yes, and I just to clarify, you're referencing text, but these are not text messages, they're Facebook messages.
Fair enough. The communication, I guess.
Yes.
Fair word, okay. Thank you, that's all I have.
Any redirect?
Briefly, Your Honor, just one moment. Could I retrieve a report?
You may.
Deputy Rolling, Mr. Puentes had previously showed you a report that was authored by Detective Grease. Do you remember that?
I do.
And I think you testified to this, but I want to make sure it's clear because I'm not sure it entirely was. Do you recall what was in that report in general terms?
Yes.
And this report, do you dispute the report's dated March 15th, 2024?
No.
And does the report reference processing evidence in this case?
Yes.
What evidence, if you remember, does this report reference processing?
They would be various clothing items and evidentiary items to be sent to the DCI for testing.
So was the report that you were shown a few moments ago a reference to processing the scene at 105 Crestview?
No.
Okay, no further questions.
Nothing based on that, Your Honor.
You may step down.
Thanks, sir.
State may call its next witness.
Your Honor, at this time, the state rests.
Right, thank you. Ladies and gentlemen, as the state has rested at this time, there's a few things I need to take care of at this time outside your presence. I would remind you of your admonition. Please do not discuss this case amongst yourselves, and please continue to keep an open and attentive mind. Thank you.
Please rise for the jury.
Let the record reflect, we're outside the presence of the jury. The defendant is present along with his counsel and counsel for the state. As the state has rested at this time, are there any motions for the consideration of the court?
Yes, Your Honor. We'd like to make a motion for judgment of acquittal.
You may proceed.
Iowa Rule of Criminal Procedure 2.19, subsection 7, subsection A, allows the defense to make a motion before submission to the jury of motion for judgment of acquittal. The burden that we have is show that the evidence is insufficient to sustain a conviction for murder in the first degree. The court then is required to look at the evidence in the light most favorable to the non-moving party or the state. In this case, there is the requirement for murder in the first degree is that we are contesting and we have been contesting, is that the defendant acted with malice aforethought, that he acted willfully, deliberately, premeditatedly, and with a specific intent to kill Taylor Escontrias. There is no evidence of this malice aforethought based on the evidence that is currently submitted. The evidence that has been submitted from the state shows that only that there is a death of Ms. Escontrias. The mental state, the state has not proven, and that is a specific requirement for murder in the first degree. They have produced no particular evidence that would show it other than the actual death of Taylor Escontrias. The defendant was being the only one with Ms. Escontrias at that time. Mr. Behal's own statements and information that they gleaned from him show a lack of mental capacity, a lack of being able to form the mental or the mens rea of this case. He did not have specific memories of this event, but just pictures or images that came up in his mind. He was in a complete blackout. This gives him insufficient mental capacity to willfully act. It also gives him insufficient mental capacity to create the other parts of this, which is premeditation, which the state has no evidence, produced no piece of evidence that shows any type of plan, planning activity, not even just a plan of, as we know, premeditation and deliberation isn't required to be any particular length of time, but there's no evidence of any planning activity in this matter. It happened, the death occurred. There's no evidence that Mr. Behal tried to hide it by cleaning up, by going to different places and grabbing different things. There's just a lack of evidence of any kind of planning activity directly directed towards Mrs. Escontrias. There's no evidence of any kind of motive. Motive isn't required with respect to intent. However, it is something that courts can consider when determining premeditation and deliberation, as stated in State versus Wilkins, sorry. Then also, there's also no specific evidence that Mr. Behal acted with a specific intent to kill Taylor Escontrias. The evidence submitted doesn't show that. The evidence that the state has put forth has only shown a very confused Mr. Behal. The officers that interviewed Mr. Behal even testified that he was confused, that they didn't believe that he was putting on a show of any sort, that he was in fact present when at the scene, not making it up, not making up that he was unconscious, not making up that he couldn't remember these things, but that he was very confused in the way that they got to even the idea that this wasn't an OWI, but was in fact the death of Miss Escontrias was just by happenstance, not by any specific questioning of the officers, but by, again, those pictures that were coming up in Mr. Behal's mind, but not specific memories of like that a normal person would have living through an event and be able to produce detail. Mr. Behal, in his interviews with law enforcement, whether it was at the scene, whether it was at the hospital, or whether it was with Detective Rolling, or now Deputy, lacked detail with what happened, how it transpired, complete lack of detail. This goes against any evidence. This goes against the idea that he has the sufficient mental capacity to act willfully, premeditatedly, with deliberation, and with malice aforethought. Thank you, Your Honor.
State?
Your Honor, the state obviously resists that motion. And in response, it seems to be that at least for purposes of this stage, the defense is conceding the first two elements of murder in the first degree. I do want to make some record on that just for completeness. Namely that the defendant killed Taylor Escontrias, and then number two, that the defendant struck Taylor Escontrias with some type of a weapon, whether that be a knife, a screwdriver, or a bat. And then secondly, as a result of those injuries, that Ms. Escontrias died. Obviously, we have the defendant making numerous admissions, or what certainly could be perceived as admissions by a reasonable jury, that he did use at least two of the weapons. He didn't remember using the screwdriver, but he did remember using the baseball bat and the knife to inflict injury on Ms. Escontrias. And then we have the testimony of Dr. Klein, whose professional opinion indicates, as well as I believe what a juror's common sense would indicate, that she died as a result of those injuries. As it pertains to the third element, that the defendant acted with malice aforethought, and the fourth element, because I think there is some overlap there, that the defendant acted willfully, deliberately, premeditated, and with a specific intent to kill. There certainly is evidence for a juror to find that both of those elements are satisfied. I would point out to the court that the defense seemed to focus on the fact that Mr. Behal stated he didn't remember a lot of the evening. There's no requirement that the state proves that he remembered any of the crime, although it's certainly clear that he remembered part of it based on his interview. I'd also point the court to the instruction on the dangerous weapon inference, which is Model Instruction 700.8, which allows the court to find, or allows a jury, I should say, to find malice, premeditation, deliberation, and that it was done willfully by the use of a dangerous weapon. I think it states over a period of time, well, I don't recall the exact language. Yeah, the instruction allows a jury to infer that the weapon was used with malice, premeditation, and specific intent to kill. In this particular case, we don't have a dangerous weapon, we have three dangerous weapons. We have a screwdriver, a baseball bat, and a knife. And I don't think there's a big dispute on whether those three weapons were all used in conjunction with each other. necessarily, using 3 weapons requires someone to change weapons at least 2 times. So we have the defendant changing weapons 2 times, at least 2 times during the course of this assault. It also occurred throughout the apartment. We have a blood stain in the kitchen, a substantial blood stain in the kitchen, a substantial blood stain just outside of the kitchen, and then we have Ms. Escontrias' final resting place by the door. The fact that it took place with multiple weapons over multiple areas of the apartment certainly leads to an inference that this assault and murder took time to complete. During that time, the defendant at any point could have formed the requisite specific intent and formed the requisite mental capacity. I'd also direct the court to the defendant's statement during the interview with Detective Rowling when he's at least trying to explain the stab wounds found on Taylor's neck. And I acknowledge that Mr. Puente certainly has room to argue that it really wasn't a confession, but a possibility, but I think a reasonable juror could certainly find that it was a confession, that he came to, saw Taylor suffering, and then decided to kill her to put her out of her misery after she'd stopped screaming. Even if there was no requisite intent up until that point, at that point, the defendant arguably, admittedly, forms the requisite specific intent to kill her to end her suffering. He doesn't render aid. He doesn't call 911. He decides to kill her at that point. And the fact that he decided to kill her, and again, not render any type of aid, certainly lends itself to a juror and the court at this stage finding the requisite malice aforethought and intent requirements. Lastly, the fact that the defendant had the state of mind to know he had to leave the scene after the murder was committed certainly supports the fact that he certainly could have formed the requisite intent, and the state would argue in the case that he did have the requisite intent. I'd acknowledge that decision likely happened after the assault and the murder, but I think we're looking at a fairly short time window where a juror could find an inference that if the defendant knew he had to flee the scene, I think he said so the cops don't get him or something to that effect, that he understood what he did, which leads to an inference that he understood what he was doing while he was doing it. So for those reasons, the state would resist the motion for judgment of acquittal and ask that the case be submitted to the jury.
Anything further from the defense?
No, Your Honor.
The court, after considering the statements made on behalf of the defendant in its motion for judgment of acquittal, and after also listening from those comments from the state, determines, and it should be stated, at this stage, the court must look at the evidence in the light most favorable to the state, the non-moving party. That is the requisite for the court at this time. And looking at the evidence that has been submitted thus far, and considering the arguments that have been made on behalf of the defendant and state, I must find that the motion must be denied. The state's arguments are much more persuasive based on the evidence that has been presented. It's duly noted that, and the court understood that would be the arguments made on behalf of the defendant as to the mental state and for his actions, and the defense even admits that it does not require a plan. It doesn't require that. No motive is needed. The defense admits that as well. And the facts clearly show that this is a fact question for the jury to determine based on the evidence that has submitted. And this court does not feel comfortable taking that fact question out of the hands of the jury, and it will go to the jury. Does the defense need time to decide how to proceed at this time?
Like a brief recess.
Of course you can. Just let me know when you're ready, and we'll go back on the record.